And then, so your other article, this just came out last month. It said the roots of wokeness, Title VII damage remedies its potential drivers of attitudes towards identity politics and free expression. Okay, that's a mouthful. Mine was just woke institutions. It's just civil rights law. So I'm going. That's different between a legal law review article and then a just a blog. But I think we touch on many of the same ideas. But there was still a lot in here that I didn't think of, and the way you put it, I think is great. I think there's regular law, and then there's there's the way law works in most cases, and I think that civil rights law just has why it had the potential, I think, what you're saying in your piece, to have an outsized cultural impact in a way that other laws don't. So, for example, we give money to farmers, right? And it's not like we became a country that ever had the potential to make us obsessed with farming. Maybe it does subsidize like rural lifestyles, and maybe there's some downstream cultural effects. Maybe country music exists because of subsidies. The U.S. Department of Agriculture. You could make some kind of argument like that. But I don't think I think most things in law are not like that, and I think civil rights law is special. So can you talk about that and what you see the connection is between law and the culture?
I think that fateful moment was in 1991 when Congress passed the Civil Rights Act of 1991, which amended Title VII. Back in 1964, the remedies that were available if you could prove a Title VII case were very limited. And by remedies, I mean, what happens when you win a lawsuit? What does the court order? Does it order money? Does it order an injunction? And back in 1964, you could get lost wages if you could prove discrimination, and you could get an injunction. You could get a court to order that a particular employer hire you or promote you or get a certain amount of salary in the future. But what you couldn't get emotional distress damages. You couldn't get that. And you couldn't get punitive damages. In 1991, they changed that. And what they essentially did is they put Title VII on steroids. Instead of it just being an ordinary cause of action where you had to be able to get, you had to be able to show lost wages in order to get money. You could get attorney's fees, but you couldn't. That was unusual, so it was generous in that respect. But now, not only can you get lost wages, an injunction, attorney's fees, now emotional distress damages, and possibly punitive damages, and that especially affected the harassment side of Title VII.
Wasn't it before 1991? Couldn't you get punitive for just race and not sex, or am I remembering that wrong? And then 91.
I don't know of punitives for anything, but you possibly could get punitives at the hiring stage under Section 1981, which is a different statute.
Okay. So, So 1991, I guess, made it easier to get punitive, or maybe start punitive for under the Civil Rights Act, but especially for you're probably right. But the sex thing is what actually took off. So 1991, we know. Go ahead.
Okay. So in 1991, things changed, especially for harassment causes of action. So racial harassment, but especially sexual harassment, because that was what was on everybody's mind in 1991.
Yeah, this was a few months after the Clarence Thomas hearings. It wasn't.
Yeah, and it's funny. The newspapers all reported that because of the Clarence Thomas hearings, that suddenly the number of sexual harassment cases skyrocketed. But that wasn't it. It was this act, and the act had already been drafted and had already said everything it was going to say about this. And it may be that a few people were paying attention to the Clarence Thomas hearings and thought sexual harassment. I think I'll file a complaint. But basically, it was suddenly you could get money for emotional distress. And for most cases of harassment, whether it's racial or sexual, there won't be any lost wages. And so prior to 1991, it was really only very serious cases that tended to be litigated. But after 1991, anybody who was upset with their employer, particularly if they'd left their employer for a different reason, maybe they'd been fired for something that had nothing to do with race or sex, and they wouldn't have been able to prove that it did. Maybe they left because they wanted to leave. But now they can turn around and say, and by the way, I was harassed. And they could get substantial damages. And, to some degree, you could say, well, that's Congress authorized it. That's what they wanted. But I bet they weren't quite thinking about all the different ramifications here. Because harassment, what is harassment? What constitutes enough harassment to where you ought to be able to bring a lawsuit? Back when it required lost wages, there just wasn't going to, it didn't matter that the definition was vague, because it had to be bad enough to have caused the person to lose wages. Either they had to be fired because they weren't cooperating with the harasser, or the harassment had to be so terrible that it was just, they had to leave before getting another job. That's going to require some kind of harassment. Now, after 1991, the fact that the definition was so vague, you never know what a jury is going to do. And that mattered a lot. What mattered, I think, even more, prior to 1991, the Supreme Court had defined harassment in a way that allowed it to be proven by cumulative incidents. So you could have like 20 different colleagues, and one of them said, gosh, you look nice today, Miss Snodgrass. And, perfectly, nice person isn't trying to harass anybody, just wants to say you look nice. Well, that could be added to, the next person in the office said something that was, told a little off-color joke that wasn't even directed at this particular employee, but she overheard it. And the next person might have posted a picture of his wife in a bikini. And, it potentially could.
These are all real cases. You're not making these up. I mean, these have things that have been cited in some kind of civil rights. All of these things have at least been the subject of litigation. I made up the name Miss Snodgrass, but all of these things have been thought of as possible contributing factors to a harassment cause of action. So because it's cumulative, every employer is suddenly thinking, whoa, if we're going to avoid, this kind of litigation, we've got to not just tell people not to act outrageously. We got to start telling them that every little thing that might contribute, we got to put the brakes on all of it, because we can never tell when you reach the point where the Supreme Court would have agreed this is serious enough to where you can collect damages. So that cumulative aspect of it is just hugely important. So immediately employers want to start, gathering their employees together and giving them a nice course on what not to do. And it would be, don't do a lot of things that previously would have been thought of as completely innocuous. Yeah. Yeah, so Eugene Volokh has a great paper on this. So he basically says it can be cumulative. You don't even know what the lines are. So basically, what do you do if you're an employer? You say, don't talk about sex. Don't make any kind of joke that could be interpreted the wrong way, because it's cumulative. It's not like, okay, here's this one person. 40% of you can make a joke or say something about their looks or something like that. That's not a workable standard.
So yeah, from that standpoint, you have to expect employers are going to do what they have to do. And prior to 1991, when they weren't thinking money damages, you'd get people, particularly on college campuses. Remember, colleges are employers just like everybody else, but there were more people who were ideologically oriented towards stopping harassment prior to 1991, and they really got the upper hand on campuses after 1991, and they just went crazy.
Yeah. I mean, I think people don't realize this. I mean, we could talk about the way the law is written. You could say, oh, it has an exception. It has this. It has that. But most people who are running a business, they're not lawyers, and they have 1,000 laws and regulations to think about, right? And so, what are they going to fall back on? They're going to fall back on hard, easy rules that are going to make their lives as easy as possible, right? So this thing like, oh, can I do this test? But business necessity, but standard of proof this, or cumulative, harassment. What's okay? What's not? They're likely, they're not going to think all that. And so you could say, well, the law technically could give you a lot of wiggle room and, this and that. You just have to think of sort of pragmatically how it gets interpreted in the real world. And most people are just going to, exactly.
it's not just non-lawyers, even like the most
Even lawyers don't know. Yes.
lawyer in the world is
Yeah.
going to say, well, technically it's not harassment unless it gets, to a pretty bad level. But what can I tell my employees other than like, don't do anything that can contribute to this? It's a perfectly rational response. And the employees then sit through a training program that says, don't do this, don't do anything that might be interpreted as a contributing factor to a harassment cause of action. And not only do the employees take that to heart and say, okay, I'm not gonna tell Miss Snodgrass that she looks nice today, but employees who might see themselves as potentially a target of harassment are now going to be especially sensitized to, gosh, if so-and-so tells me that I look nice, maybe that's really not very nice. I used to think of that as something that was nice when someone complimented me. And now I think of it as maybe, I should. Maybe I was being silly in the past for thinking the person was nice. Maybe down deep, they're really just trying to harass me.
Yeah. Yeah. I mean, you do create a financial incentive to look at it one way and not another way.
Absolutely. Absolutely.
Yeah. But so one thing about one thing I really liked about this article is that when I wrote my article, I put the blame on the innovations in civil rights law after the 1964 Act. So disparate impact and the affirmative action executive orders, which we haven't gotten to. But basically, and a lot of people said, okay, well, wokeness seems more recent than that. And I sort of didn't really have a good response to that. But I knew of the existence of the 1991 Civil Rights Act. But I think what I learned from your article was just how important it was. And so if you look back at sort of a timeline of when this stuff started, yeah, I mean, wokeness in 1991 is not the same thing as wokeness in 2010. I mean, it's definitely got a different flavor to it. And there's new stuff like trans issues and stuff like that. But, when you look back when sort of people started talking about PC as like a big enough issue to get people's attention, it was the 1990s, right? So the timeline does match up. You mentioned about the universities, how after 1991 they got the upper hand, the people who wanted to censor speech, and basically the wokes started to move into power. Can you talk about that a little bit? Do you connect that to the 1991 law? Do you think there's a case to be made that there's a connection there?
Oh yeah, I think there is. I mean, on every campus, like during the late 1980s, when you started to get these hate speech codes, the courts basically, struck back, and a lot of these hate speech codes did not turn out to be that much of a problem in the early 90s. But like as time goes on, if you figure there are people on every campus, and usually the general counsel who will take academic freedom seriously, will take the need for free expression seriously. They know they're a university, but their job is to keep the university out of trouble. And so they kind of switch sides if they're practical and thinking, what I've got to do as general counsel or as associate general counsel at the university is keep the school from getting sued. Then they start leaning in the direction of the folks with the strong politically correct ideology, because they know, hey, otherwise there's going to be a lawsuit, and we will lose some of these lawsuits. So they kind of switch sides over to the practical-minded administrators, start becoming sympathizers with the progressives who want strong controls on speech. And I think for that reason, because the progressives with that ideology were already on campus and they're already pressing for this, universities, I think, have gotten it worse than anywhere else. Meanwhile, the federal government started demanding more Title IX officers on campus. So you get people whose whole job is about this. And you have to add to that, there's like another aspect of the law that I think made this worse than it otherwise would be. And it's an aspect that is understandable. There was already law that an employer cannot retaliate against someone who makes a complaint. And you can see why that would be true. You don't want to say, so-and-so is complaining that they were discriminated against on the basis of sex or race, and that wasn't true, but we fired them because they made a complaint that we did. And they developed this notion in the law starting in the 1960s and 70s that you can't retaliate against someone who makes a complaint. Well, fast forward to the 1990s and the early 2000s, every time someone on campus makes a complaint, the university officials have in mind that they're not supposed to tell this person, you're an idiot. That's ridiculous. They sort of like, oh, well, we'll take this very seriously. We'll investigate. And that just, enters the culture in itself, where people are used to the notion that if you make a complaint, suddenly everybody will sit up straight and take you very seriously. And that has not, that's not been a good thing.
Yeah. Yeah, it's fascinating because it's just such a different way of seeing the woke phenomenon than but I think what most people imagine when they're critics of the critics of it, right? So I think most people imagine just sort of the ideas are just like operating sort of in a free marketplace of ideas, right? They're having a force of their own. So somebody complains to the university administrator. The university administrator is either sympathetic to free speech or sympathetic towards multiculturalism and diversity and this stuff. And I guess what's happened in the last 20, 30 years, they'd say as well, the administrator has become, believes less in free speech and now believes in, whatever. And the same thing with, everything else. Oh, the corporation, woke capital, right? Oh, MasterCard must have just become, very interested in sexual orientation and gender identity, lately without any connection to anything else going on in the world. And, I think, I think your view of the world, and my view of the world is most people are not ideologues, right? Most people are not like me or you or like the wokes. They're not sitting around. They don't have a strong opinion on free speech is better or diversity and inclusion are better. They're just trying to do their day job, and they're trying to not get in trouble and not cost their company or their institution a lot of money. And they're trying to get along with people. And in that case, the law can have, a huge effect because the law is just sitting there and it's just sort of putting its thumb on the scale. Mm-hmm. And if people are just going along to get along, cumulatively, it becomes a really, really big deal. And eventually you see every institution taken over by these ideas.
Yeah, exactly. These major corporations, at some point they started hiring people into offices who could deal with the problem. And they got colonized in that way. And they're, the average person working for these corporations wants to make sure that things run smoothly, that they don't get sued, they don't get protesters. And after 30 years of this, it affects the culture. People start thinking along those lines. Always important to recognize not only does culture affect law, that we pass the laws that we believe in, presumably, or that members of Congress, members of state legislatures, city councils, administrative agencies believe in. But the law affects the culture as well. We're all trying to navigate successfully through this maze of laws, and that has an effect, a very powerful effect, particularly over long stretches of time.
Yeah. I've always thought the idea that basically culture is the main force here and law is like there's limited to do. I thought that was always very sort of convenient for Republican politicians. I don't know if they invented that idea, but it's sort of very convenient for them. Politicians, what can we do? It's just the culture. It's just there's nothing that for a government to do in in an open society if we're not an authoritarian regime. If it's just culture, you can't change the culture.